Thank you very much for the warm introduction, the gracious introduction, and a very good evening to everyone from Tasmania. And thank you to the Permanent Bureau for this invitation to open this track. It's a great privilege, especially given the profile of the other keynote speakers, but also the profile of the speakers within the relationships track, many of whom I'm privileged to know. I'd like to start my words today with what's becoming happily a standard practice in Australia, which is an acknowledgement of country. I'm joining you from a locality called Blessington, and I'd like to pay respect to the traditional owners of the land I'm on, and to their elders past, present, and emerging. This is an especially poignant statement for me today, because I'm joining you from my dad's old shack. My father passed away recently, and actually left a piece of land here overlooking Ben Lomond, which is this mountain in the photo, or in the painting, to me. This fact is now recorded on a register of titles that's kept by the Tasmanian government. I can walk all over it and I can call it mine. My ownership is recognised not only under Australian law, but under the principles of private international law and virtually all municipal laws around the world. Certain structures, such as a trust, for example, may not be quite as portable, but generally its legal treatment is at once certain, but also responsive to my needs and wants as a legal subject in an increasingly globalised world. One day, that register could take the form of a blockchain data entry. Reasonable minds differ about the desirability of that, but many teams around the world are working on the tokenization of land, such that rights like mine can take flight around the world within novel transactional structures. Of course, when I say that I own this land, it means something quite different to what ownership looked like under customary Aboriginal law before white settlement. I own a freehold estate in fee simple, which is a subordinate estate under the so-called radical title of the British Crown as the Crown in Right of Australia. And that estate in fee simple is the object that would be tokenised and dealt with. From the perspective of its original owners, however, much of this would appear very strange. Why should an investor in Dubai own a slice of this at all? And the deeper point is that we are all, to different degrees and in different ways, the beneficiaries of different rule sets. Those rule sets compete for the hearts and minds of human beings, and those human beings become the hands and feet of the ideas that are immanent within the rule set. We could call this law as meme. Those hands and feet then compete for primacy in the world. In the case of Tasmania, through guns, germs, and steel, and in our century of hybrid physical and digital spaces, through cyber means as well. Of course, every colonial history is different, but as the European colonial expansion was fueled by the movement of restless pilgrims, outcasts, adventurers, and opportunists, today we're building new realms of social interaction that appear to us much like infinite digital Americas, where communities can gather and self-organize beyond the reach of the old world order. Indeed, communities create institutional normative orders and project these orders onto the world. The physical world, most obviously, but also onto social artifacts, which are themselves the product of other institutional normative orders. To use an indigenous example, for example, throwing a spear through another's leg is characterized as wounding or even murder by the law of the colonial state, but it's the legal and proper response to a list of grievances in traditional law. A business corporation is a legal person from the perspective of modern Western law, but this would not have made sense as a category in any Western legal system prior to the 12th century. Financial documents were given one status in the medieval lex mercatoria, but this status was not necessarily recognised by the law of territorial sovereigns in Europe until the fabled reception of the law merchant, for example, in England by Lord Mansfield. The whole idea of private international law is framed against the backdrop of the Westphalian nation state. The Hague Conference itself is based on the agency of nation states in an act of mutual self-recognition. Things like indigenous communities and churches are not part of it. But this Westphalian nation state which is the paradigm from which most of us view the world, was forged in the crucible of a conflict between a transnational universalist religious empire, the emperor, and his territorial princes in Central Europe. It's marched across the globe in the wake of European colonialism, and it's provided the context for modernity with all of its wonders as well as its horrors. Many things of value were lost and destroyed, intentionally or unintentionally. Social structures that had existed and evolved for thousands of years were swept aside. Rights and obligations regarding land, family, and kinship, war and peace were nullified just as the land was cleared for grazing, under the ownership, often, of joint stock companies like the Van Diemen's Land Company, with huge land grants under the newly asserted title of the British Crown. What I want to remember is that the path dependency of the invisible, weightless social fabric around us, we too often take this for granted as given. And I think that's the importance in this place of making acknowledgements of country. It teaches us about the danger of transition and translation between rule sets and what can go wrong. That is, in part at least, the task that stands before us as we approach the interaction of state law with the rule sets implicit and explicit within the new distributed communities that have formed in the last decade since the launch of the Bitcoin blockchain. At base, all this is about relationships. Relationships between individual humans within structures such as the family, the clan, city, state, company, club, association, foundation, or trust. Relationships between these groups of organized individual humans. And also relationships between individual humans and groups of humans vis-a-vis objects, which we often talk about as property. Humans are a technological species, and the technologies that we use condition and inform the relationships that we build. Going back, the arrival of double-entry bookkeeping in the Western Renaissance and the invention of the printing press paved the way for complex social structures such as joint stock companies and insurance houses. These technologies enabled new forms of social coordination that were not possible on such a scale without them. In turn, new technology-mediated social structures radically changed humans' relationship not only to each other, but also to their world. Bearer shared certificates traded in London on anonymous secondary markets, giving rights to land that was being exploited and changed beyond recognition here in Tasmania. Our attitudes towards these new structures evolved over time. In the earliest days of the common law corporation, for example, corporations were considered to be in the nature somewhat of trusts and as creatures of public law with public duties. This gave way to the laissez-faire thinking of the 19th century, and it wasn't until the 1930s in the United States that we saw a reaction in the Burl-Dodd debate about the social license for corporations and for whom they were actually trustees. Today, their managers were actually trustees. Today, some of the same questions are arising as new technologies for social coordination are introduced. This is particularly true in the decade post-GFC, as unconventional monetary policy has become the new normal, redoubled in the COVID-19 pandemic. An attitude of skepticism and iconoclasm has motivated builders of the DeFi movement, for example, but recent events have given us pause to question whether the new Jerusalem is not just the old Babylon in a different dress. On a deeper level, foundational technological shifts are emerging that I think will change things permanently, whether for good or for ill. Probably nothing illustrates this better than decentralized autonomous organizations, or DAOs, on which less work has occurred to date than their close relations and constituent parts, smart contracts and digital assets. A DAO, as we'll learn in this track, is a group of presumably human token holders organized not by human officers, such as directors and managers, but by smart contracts. They respond to the world in a more or less autonomous way and are hailed by many as the next big institutional technology. As a verb, organization refers to the appointment of organs as something constitutive of the group as such. The boundaries of organization and the ontology of groups themselves are being pushed by the arrival of algorithms that can replace humans in coordinating individual action and economic coordination. There is a powerful potentiality in the intersection of intelligent decision systems with smart contracts that automate transactions in a way prima facie attributable to a group of humans, or perhaps not at all. These structures are posing basic questions about the adequacy of municipal law. Can a DAO own a forest, for example, or anything else? Is a DAO an entity? Is the DAO as an entity the nexus of smart contracts or the body of token holders? Why is this important? They're also raising questions about private international law. The situs of my land is obvious, but what's the situs of its tokenized avatar? Where do we locate or naturalize a DAO which has members everywhere distributed across the globe? Where is an open permissionless blockchain like Bitcoin? And are these even the right questions to be asking? Or should we be thinking in bolder, brighter colours? Indeed, recently a smart contract was sanctioned as an entity by the US government, raising a host of questions about what it means to be an entity in the first place. This track covers the most pressing issues and questions within this broad rubric. It strives for a deeper examination beyond just applications of DLT as a register of transactions or a medium of exchange. In a sense, it seeks to contextualize these developments in a broader what and why, as well as how. It seeks to address how users apply DLT and smart contracts as building blocks for new ventures, frameworks, and institutions on-chain. The track features a number of presentations from amazing colleagues, many of whom I'm privileged to know. These are on online dispute resolution, algorithmic law and smart contracts, national perspectives on DLT and Web3 adoption, games, remedies, DAOs, and importantly, ensuring that crypto and Web3 promote ESGs. With this keynote, I've been tasked to focus on the trajectory of DLT and Web3 as tools for social organization. As mentioned, that raises jurisprudential questions about the nature and the role of the state, of international governmental organizations, and of self-organizing non-territorial communities, about the nature of cyberspace and the rules that apply or do not apply there. These questions have a municipal, public international law, and private international law dimension. They go all the way down. They're at once highly conceptual and abstract, and immediate and practical. My urge for this conference is to be mindful not only of the black letter and technical questions, but to strive for an adequate jurisprudential grounding. How does the nature of organization change when technological mediation of human relationships changes? What happens when the connection between a territorial jurisdiction and a group of humans is attenuated? Can humans generate valid, effective, and legitimate rule sets even when not bound by geographical proximity? How do we respond to increasingly agentive machines who act in a way that's difficult to attribute to human beings, in a way that's largely autonomous from human intervention and control? It's my view that the next 10 years of development will be characterized by greater engagement with private law, including private international law, foundations of Web3. This is necessary to deliver on the promise of an internet of read, write, own. It's necessary to control the potential for abuse of consumers and for disruption and instability in our financial and economic system. Those who know me know that this has been a hobby horse of mine, and it has been since I became interested in the technology about 10 years ago. In previous presentations, I've spoken of a smooshing of the world of law and the world of blockchain. I've very cheesily punned that le loi est mort, vive la loi, and I've cautioned to mind the gap between blockchain-based structures based on sometimes techno-libertarian assumptions about the nature of law, politics and society, and the world of law. I think that a sea change can be felt now, partly as a result of the reddening regulatory heat map, partly as a result of mainstream retail and institutional adoption, and partly the result of the crypto movement's internal maturation as projects have arisen, failed, and been redesigned. I think that we're entering an age of reconciliation and integration. Rather than competition between communities and their normative orders, I think we should frame it as one of cooperation and collaboration. The overriding concern is to avoid distortion as ideas, concepts, practices, and structures are transferred, transplanted, translated, or transposed from one rule set into another. I think there's probably never been such an exciting time to be a lawyer interested in these sorts of things. It's a privilege and a significant undertaking. Whether or not one believes that legal certainty is necessary for a market, for example, a market in crypto assets to exist, I think it's fair to say that markets benefit from legal certainty. As Sir Geoffrey Voss said some years ago, things like smart contracts, digital assets, and DAOs are not going to realise their potential in terms of adoption until their legal foundations are clarified. The events of the past year, I hope, have vindicated Sir Geoffrey's view and convinced many within the crypto community of the important work that this conference and those like it are doing. Legal certainty is not likely to be achieved through the straightforward application of existing law, however. DLT-based structures are novel, hybrid, and dynamic over time. Despite our best efforts, there will be problems. Some people like to talk about technical architectures as naturally given facts. They exist, they function, and they're free from the human stain. But there's no immaculate conception here. These things are all artifacts created by people for a certain purpose, usually to mediate a relationship with other people, often vis-a-vis things, in a way that's beneficial to the creator and those that she cares about. State law and coherent rules of private international law will help to mitigate fallout when a stablecoin issuer, for example, is insolvent, or when a Bitcoin millionaire dies intestate. Finally, we should all be turning our efforts towards responsible design. It's not good enough anymore, if it ever was, to put something out in the wild and disown responsibility for its actions. This touches on a fundamental question of value and principle. I hope that builders are internalizing the importance of responsible design, especially to avoid financial crime, to protect consumers, and to promote rather than endanger systemic resilience. Beyond the financial context, I hope that builders are not only acting on good intentions, but also doing the difficult task of interrogating their own beliefs about the world to ensure that the social structures, the institutionalized relationships that they are encoding and enabling are good for humans, good for other species, and good for the natural complex systems on which our collective survival depends. From a 30,000-foot view, I think there are three main questions facing us as we seek to ground crypto law for the year 2020X. By this, I don't necessarily mean to subordinate crypto law to state law, although most of us here are probably quite bullish on the primacy of state law. At the very least, I think the nation states are the most legitimate locus of legislative and political authority in the world today, but we do live in geopolitically interesting times, and reasonable minds do differ on the norm-generating legitimacy of other groups. Rather than that old chestnut, I want to ask how we can ground both state law and crypto law within a broader framework that allows us to conceptualize and regulate the cross-pollination that we can already observe to be occurring between state law and crypto structures and back again. The first step, I think, is appraising ourselves of the various layers of the socio-technical stack. Cyberspace is out there in the ether, everywhere and nowhere, but it is also built on physical infrastructure that has a history, is often state-owned or sponsored, and lies in some state territory. Likewise, these stacks have governance structures, which are at present too often informal and unstructured, often consisting of a group of core developers on a Discord channel. But they too live, eat, and sleep somewhere. They're not yet floating on ocean cities, nor finding themselves on off-planet outposts. However, watch this space. Next, we need to choose a frame of inquiry. My colleague Carla Reyes has suggested comparative law, treating crypto legal structures as legal transplants from another legal system into state law. My colleague Rosa Lastra and I, building on her past work on the Lex Financiera, have recently suggested that legal pluralism might be more fitting to the task, as it interrogates the central question of norm-generating authority, which comparative law, in my view, assumes, and it also tessellates with the existing learning and literature on transnational financial and economic law, soft and hard. As my amateur Indigenous law musings at the start of this presentation probably revealed, I am somewhat of a legal pluralist at heart, and I would enjoy seeing such a project unfold. Finally, to the extent that we do want things like smart contracts, digital assets, and DAOs to travel into state law and to be recognized as denizens there, if not citizens, we need to find ways to ground them in municipal law that's somewhat consistent across jurisdictions and internally coherent with the dogmatic structure of that domestic law. As my colleagues from the Unidroit project on digital assets will attest, this is no mean feat, but it's not impossible either, and amazing progress has already been made. The Law Commission of England and Wales has also recently presented a remarkable effort towards that end. There's much more that I could say, but my time is up. So I would like to thank again the Permanent Bureau for this invitation, and to thank my fellow speakers on the relationships track for their excellent presentations, which will follow over the course of the coming days. Thank you and good night.